classmate over whether INS versus Chadha was correctly decided. Judge Kavanaugh seemed delighted to hear both sides, and he encouraged us to develop our conflicting views. With Judge Kavanaugh, I was confident that if I could make the right argument, he would accept my position. My belief in Judge Kavanaugh's open-mindedness has deepened over the years through my one-on-one conversations with him. I often can't resist sharing my views on separation of powers issues, and he is invariably an engaged listener and an insightful questioner, despite the fact that we come from different sides of the political aisle. Second, in my experience, Judge Kavanaugh is highly principled. By that, I mean something very specific. He carefully delineates the difference between policy preferences and what the law demands. In the separation of powers class, we often discussed current events and the way they implicated various constitutional concerns. Policy considerations inevitably came up, and we certainly discussed those. But the judge would repeatedly remind us that those policy concerns are beside the point if the Constitution dictates a different outcome. More generally, the judge taught us that the way to discern the legal principles that undergird our democratic system is to look to the text, history, and precedents regarding the Constitution, not our policy preferences. Third, Judge Kavanaugh is even-handed and treats people fairly and with respect. In class, he gave the same consideration to the views of all students. I consistently felt he was judging our answers based on our ability to reason clearly and support our points, not based on any political or ideological standard. Judge Kavanaugh's even-handedness goes beyond respect for varying ideologies. In my experience, he treats everyone equitably, regardless of their gender, race, or background. One would think, or at least hope, that in 2018, that should not be remarkable. But as a woman, I know that explicit and implicit bias continue to plague the legal profession, just as they plague the rest of society. Far too often in my career, I have felt that I was being treated as a female lawyer, rather than just as a lawyer. But with Judge Kavanaugh, I have never felt that way. In my interactions with him, I know that I am being judged on the merits of what I say, nothing less and nothing more. I believe that a person with such sterling credentials and experience as a judge, who so clearly values integrity, principle, and fairness, is eminently qualified to serve on the Supreme Court. I therefore enthusiastically support Judge Kavanaugh's nomination. Thank you for your time.
Thank you very much. Now, Professor Murray.
Chairman Grassley, Ranking Member Feinstein, thank you so much for the opportunity to appear at these hearings on the confirmation of Judge Brett Kavanaugh to the United States Supreme Court. My name is Melissa Murray, and I am a professor of law at New York University School of Law, where I teach constitutional law, family law, and reproductive rights and justice, and serve as the faculty co-director of the Birnbaum Women's Leadership Network. Prior to my appointment at New York University, I was the Alexander F. and May T. Morrison Professor of Law at the University of California, Berkeley, where I taught for 12 years, served as faculty director of the Berkeley Center on Reproductive Rights and Justice, and served as interim dean of the law school. Like Judge Kavanaugh, I too am a graduate of Yale Law School. Over the course of these hearings, much has been made of Judge Kavanaugh's warmth and kindness towards his clerks and those in his community. These accounts resonate with me, as Judge Kavanaugh and I have traveled in similar professional circles over the years. In fact, I too have had lunch with him, and I can attest to his friendliness and charming demeanor. But this nomination is not about whom I would befriend or with whom I would have lunch. It is not about how Brett Kavanaugh treats a handful of women from elite institutions. It is about real people on the ground. People like the women to my right and the people they represent, who will not have lunch with Judge Kavanaugh, who will not meet with Judge Kavanaugh, but who will nonetheless depend on Judge Kavanaugh to protect their constitutional rights to make decisions about their lives. As you've heard from women like Alicia Baker and Liz Weintraub, confirming Judge Kavanaugh to the Supreme Court would threaten people's ability to make fundamental personal decisions, including deciding whether to have an abortion. Reproductive rights are under serious threat in this country. What we have seen over the last 2 decades is a concerted strategy that would dismantle Roe v. Wade piecemeal, not in one fell swoop, but rather through a death by 1,000 cuts. This nomination is the culmination of that decades-long effort to destroy Roe v. Wade incrementally, without necessarily formally overruling it. The Supreme Court stands as a bulwark against this assault on reproductive freedom. Just 2 years ago, in Whole Women's Health versus Hellerstedt, Justice Kennedy joined a majority to reaffirm the undue burden standard first articulated in Planned Parenthood versus Casey, thereby reaffirming the court's commitment to protecting reproductive rights. But Judge Kavanaugh's nomination to replace Justice Kennedy imperils the court's ability to continue to hold the line on reproductive freedom. In Garza versus Hargan, the only abortion case to come before him, Judge Kavanaugh voted to block a young immigrant woman from receiving abortion care and insisted that she remain pregnant against her wishes, weeks after she had made her decision and after she had completed all of the state-imposed requirements. Although he claimed to follow Supreme Court precedent in Garza, Judge Kavanaugh's opinions evinced a crabbed and skeptical view of these precedents, a view that is completely out of step with the High Court's own view of those cases. Despite his claims during these confirmation hearings that he was respecting Supreme Court precedent on minors and abortion, in fact, his dissent shows the opposite. He ignored the Supreme Court's holding in 1979's Bellotti versus Baird that allows minors to complete a confidential judicial bypass in lieu of parental or guardian consent. Jane Doe had already met the Texas requirement of a judicial bypass by the time her case came before Judge Kavanaugh, so further delay to seek a sponsor was wholly unwarranted. Further, Judge Kavanaugh did not explain how the government's flat prohibition wholly preventing Jane Doe from accessing abortion failed to constitute an undue burden under Casey or a pre-viability ban under Roe. Nor did he weigh the potential harms to Jane Doe stemming from a further delay against the purported benefits of that delay, as is required by Whole Women's Health. Judge Kavanaugh's record in Garza suggests that rather than respecting precedent, he will undermine or ignore it. And in so doing, he will provide the necessary fifth vote that would utterly eviscerate the right to abortion. During these hearings, when asked by you, Senator Feinstein, whether he agreed with the statement that a woman's right to control her reproductive life impacts her ability to participate equally in the economic and social life of the nation, Judge Kavanaugh's reply was not, "I agree." Instead, he said, "I understand the importance of the precedent set forth in Roe v. Wade. We have seen this before." In 2005, then Judge Roberts came before this committee and stated that Roe is the settled law of the land during his own confirmation process. Despite this earnest declaration, as a justice, he voted to uphold a statutory scheme that would have shuttered 75% of the clinics in Texas. If this is what it looks like to respect precedent and treat Roe as settled law, then these are empty promises. Since 2011, politicians have passed over 400 new laws in 33 states across the nation that shame, pressure, and punish women who decide to have an abortion. Some of these laws would ban abortion as early as 6 weeks before a woman may even know that she is pregnant. Others would require doctors to convey a falsehood to patients, telling them that abortion leads to breast cancer. The point of these restrictions is to make it difficult, costly, and in some cases impossible for women to obtain an abortion. And as such, these restrictions impede women's ability to participate equally in the social and economic life of the nation. And these restrictions are especially detrimental to young women, women struggling to make ends meet, women of color, immigrant women, rural women, and women who have already had children. In practice, these restrictions mean that Roe is merely a hollow promise and not a reality for many women. To be clear, Roe v. Wade is not a decision invented by activist judges. It is part of a century's worth of jurisprudence that protects an entire constellation of rights. Rights relating to family, marriage, parenthood, contraception, and personal autonomy in intimate life. A vote against Roe is whether to overrule it as a formal matter or gut it through incremental cuts, puts all of those rights in jeopardy. And make no mistake about it, A vote for Judge Kavanaugh is a vote against Roe. Thank you for having me.
Thank you, Professor Murray. Now, Professor Amar.
Thank you, Chairman Grassley, Ranking Member Feinstein, distinguished senators. My name is Akil Amar. I'm the Sterling Professor of Law and Political Science at Yale University, where I specialize in constitutional law. I've previously testified before this committee on 7 occasions, and it is always a solemn responsibility to appear here. Here are my top 10 points. Point 1. Brett Kavanaugh is the best candidate on the horizon. The Supreme Court's biggest job is to interpret and apply the Constitution. Kavanaugh has studied the Constitution with more care, consistency, range, scholarliness, and thoughtfulness than any other sitting Republican federal judge under age 60. He's the best choice from the long list of 25 potential nominees publicly circulated by President Trump. I say this as a constitutional scholar who voted for Hillary Clinton and strongly supported every Supreme Court nomination by Democratic presidents in my adult lifetime. Point 2. Originalism is wise and nonpartisan. Studying the Constitution requires diligence and intelligence, especially for those, like Kavanaugh, who are originalists, paying special heed to what the Constitution's words originally meant when adopted. I, too, am an originalist. In prioritizing the Constitution's text, history, and structure to discern its principles and distill its wisdom, we originalists are following in the footsteps of George Washington, Alexander Hamilton, James Madison, John Marshall, Joseph Story, and Abraham Lincoln, among others. Originalism is neither partisan nor outlandish. The most important originalist of the last century was a towering liberal Democratic senator turned justice, Hugo Black, the driving intellectual force of the Warren Court, who insists on taking seriously the Constitution's words and spirit, guaranteeing free speech, racial equality, religious equality, the right to vote, the right to counsel, and much more. Among today's scholars, the originalist cited most often by the Supreme Court is also a self-described liberal and registered Democrat. Yours truly. The best originalists heed not just the founder's vision, but also the vision underlying its amendments, especially the transformative Reconstruction and Women's Suffrage, Reconstruction Amendments and Women's Suffrage Amendment. I believe that Justice Kavanaugh will be in this tradition on various vital issues: voting rights, governmental immunities, congressional power to enforce the Reconstruction Amendments. Justice Kavanaugh's constitutional views may well be better for liberals than were Justice Kennedy's. Point 3. Kavanaugh's writings reflect proper respect for tradition and precedent. Originalists start with the Constitution's text and structure, but almost always need to consult other constitutional sources, such as tradition and precedent. Harmonizing these different constitutional sources requires great legal acumen. Kavanaugh's record shows that he is adept at harmonization. Point 4. Kavanaugh's views on executive power have strong constitutional foundations. Many of Kavanaugh's views about the executive branch are quite standard. On several other executive branch topics, Kavanaugh's views are not yet conventional wisdom, but are nevertheless sound and indeed align well with the testimony I offered this committee in 1998 and 2017. Point 5. The best basis for assessing would-be Justice Kavanaugh is the track record of Judge Kavanaugh. The judicial track record is more proximate and relevant than Kavanaugh's prejudicial life. Point 6. Kavanaugh would work well with his new colleagues. I predict that Kavanaugh, a studious and open-minded conservative who likes listening to and engaging with moderates and liberals, will be a pro-intellectual and anti-polarizing force on the court. Point 7. Judicial nominees should not make substantive promises about how they would rule on specific legal issues, nor should they make recusal promises that closely approximate substantive promises. Point 8. Senators may properly oppose the judicial nominee simply because they disagree with the nominee's general constitutional philosophy or likely constitutional votes on the bench. Point 9. The current Senate confirmation process is badly flawed and should be changed for future vacancies. Point 10. Back to point 1. Responsible naysayers must become yay-sayers of a sort. They must specifically name better nominees realistically on the horizon. If not Brett, who? Distinguished Republicans, Kavanaugh is your team's brightest judicial star. Rejoice. Distinguished Democrats, Don't be mad, be smart, be careful what you wish for. Our party controls neither the White House nor the Senate. If you torpedo Kavanaugh, you'll likely end up with someone worse, someone less brilliant, less constitutionally knowledgeable, less studious, less open-minded, less good for America. Thank you.
Thank you all very much. Before I ask my questions and take 5 minutes to do that, Senator Tillis is going to chair this committee after I get done asking questions for this panel. I should say I'll be back, but because I'll be gone when you separate, I want to thank all of you for your participation in this process. And then I think after this panel, it's scheduled that we would have a lunch break. I'm going to start with Mr. McLeod because it seems to me you've clerked for different people of different views on interpreting the law and the Constitution. Judge Sotomayor, I believe, and then also Judge Kavanaugh. So I'll let you define yourself what the most important characteristics of the Supreme Court justice is, and if you see Judge Kavanaugh meeting these.
Well, I think the most important characteristics are, first of all, intelligence and faithfulness to the law. I think Judge Kavanaugh, as his reputation shows from his years on the D.C. Circuit, has those characteristics in spades. I think something that's maybe underappreciated in terms of the work the Supreme Court does is how closely the justices work together. And I share Professor Amar's view that Judge Kavanaugh would work well as a colleague on the Supreme Court. He's talked during these hearings about the idea of a team of 9 working together with his colleagues on the court to achieve a goal of justice and interpreting the law fairly. And I think that he would live that model if he were appointed to the Supreme Court.
No, thank you. I'm going to ask Ms. Gary this, but it's based upon a very strong point that Professor Murray made, that we hear a lot about what Kavanaugh has done for people that have worked close with him. She fears that he may not take the average American's point of view into mind in his work as a judge. So what would you want the average American to know about Judge Kavanaugh as a person and how he might see their problems, not the people he's associated with all of his life? Push the button, will you?
In my experience, Judge Kavanaugh listens and hears everyone he speaks with. I do think he considers people from a variety of backgrounds. I don't think he's lived only in one sphere. I think he has exposed himself to a wide range of people, and I think that he would listen empathetically and hear their voices.
And probably a point he's made and how he serves for low-income people at congregate meal programs, as an example. Would be one way I would see from what he has said. Ted Olson, you are famous in the legal community in this town and around the country as well. So you ought to interact with a lot of people that in turn have interacted with Judge Kavanaugh. What do other members of the legal profession say about the experiences that they've had with Judge Kavanaugh?
Thank you, Mr. Chairman. That's a very good question. The fact is that throughout his legal career, I have heard nothing but the highest praise for Judge Kavanaugh as a human being, as a lawyer, and as a judge. As far as I can tell, and as far as I have heard, he is uniformly respected by his peers on the D.C. Circuit, with whom he has worked in many cases for 12 years or more, including also the most recent appointees to the court. Every lawyer that I have spoken to who has appeared before Judge Kavanaugh has respected the experience and has related to me the fact that he has listened, he pays attention. It's impossible to tell exactly how he is going to decide until you read the decisions that he makes. So in summary, the answer to your question is, I do not know of a lawyer or a judge who is more uniformly respected in terms of his personality, his character, his integrity, his fairness, and his competence.
Ms. Sinzak, you obviously remember him as a good teacher. What are those qualities, if you can transfer them to being a good judge and eventually a Supreme Court justice? What would you say about what you learned to him in class versus his being a judge?
I think the qualities are directly transferable. I think he was a great professor because he not only listened and engaged more than he talked, but he knew how to get people explaining their arguments in the best possible way. And I think that as a judge, too, he needs to listen to everyone before him. He needs to be able to engage with different viewpoints. And then also he needs to be able to treat those viewpoints equally. And as in our class, I think that he was open-minded and wanted to listen to people of all ideologies equally, wanted to hear the different sides of a discussion. And similarly, I think that as a justice, he will listen to both sides of an argument. He will consider those. And then thirdly, he knows what's important in the law. I mean, he wasn't just a teacher, he was a law professor. And what he told us was that what matters in the law is what the law says, not what your policy preferences dictate. And I think that in many ways that's the most important quality for a justice, and I think that he exhibited that.
Senator Feinstein.
Thank you very much. I want to just pick up on the last sentence that you said, that the issue qualities really shouldn't matter. It should be the fairness, the likability, the qualifications only. And that might be fine if some of the critical things that many of us, and I'm going to speak for myself as a woman who's been a mayor, I represent 41 million people, and Ms. Baker, America is like you out there today in the young woman. I see it over and over and over again. And Ms. Weintraub, I am so proud of you. Stand tall, be strong. You're quite wonderful to be here today. So, and Professor Murray, I think you were very cogent. I thank you for your remarks. I've never, in all my years here, been with a panel, the majority of whom are women, and each one of you brought a different point of view, and it is very, very welcome. For me, Ms. Garza, I wanted to ask you a couple of questions, if I could, because the Jane Doe case is really a problem for me, because what it showed was there were so many things in her treatment I didn't like. The way she was treated by the Office of Refugee Resettlement, she was subjected to unnecessary sonograms, forced to go to a crisis center, subjected to harassment, as I understand it, had been physically abused by her parents, and went to a Texas judge and received an order of approval. I don't have that order of approval. What did that order of approval say?
Well, in Texas, you have to get a judicial bypass to bypass the consent from your parents and to consent to your own abortion care. And that order is typically based on a best interest assessment, whether or not it's in Jane's best interest to go ahead and proceed with making that decision on her own, or whether or not she's sufficiently mature enough. So in this case, it was in her best interest to go ahead and proceed with that. Texas court decided that, and that's how the case moved forward.
Now, the panel that the nominee in question was on, were questions asked? Were you there?
No, I was.
It was an appellate court, I understand that.
No, I was not there. However, I did listen to it. The question was not the order was not in question. A Texas court made that decision. Jane went through every single hoop she needed to go through in Texas, including complying with the Texas law, the 2 days, and she was just being blocked. She wasn't being allowed to go to her medical appointments, and she wasn't allowed to be released to her ad litems. to myself as her guardian ad litem or her attorney ad litems that were appointed by state courts.
And why was that?
Just to obstruct her ability to enact her decision. It was a policy enacted under ORR, and they directed the facility not to allow her to be released.
So, Professor Murray, I think the arguments have been made here, and my great query is women have never historically been treated equal, and finally, we got the vote, it began to change, we were able to go to higher education, the United States began to accept women, and now the world seems to be changing in favor of women. What I am most worried about this is that Roe goes down. And for what this meant in my generations, which were the 50s and 60s, when the death toll was estimated to be between 200,000 and 1,200,000 of women that went to illegal abortionists and died. I don't want to see us go back to that day. And so that is inherent in this vote. Weapons in this country are inherent in this vote. And if you look at where America is going, also the quality of the individual who's going to sit in that deciding seat, I think overwhelms most else. Your analysis, and you spoke very cogently, how would you analyze this judge affecting those issues?
Thank you, Senator. It's clear to me, reading Judge Kavanaugh's opinions on these reproductive rights cases, that he says he is following Supreme Court precedent, but that is not the case. In the Garza case, which is the only abortion case to come before him, Judge Kavanaugh said he was following the settled precedents, yet he did not even engage the question in Whole Women's Health versus Hellerstedt, which would have required him to weigh the benefits of a delay against the burdens it would have imposed against Jane Doe. That's required by the Supreme Court under its most recent decision in Whole Women's Health versus Hellerstedt. He did not engage that at all. In requiring that Jane Doe take an additional 11 days for the government to seek a sponsor, his decision defied Bellotti versus Baird, a 1979 case where the Supreme Court held that a state cannot require a minor to obtain parental consent or even to notify a parent unless it provides an alternative judicial bypass option for determining whether an abortion is in the best interest of that minor. And as Ms. Garza has said, Jane Doe went through that state-required procedure to have a judicial bypass. She obtained that bypass. A Texas state judge determined that an abortion was in her best interest. The government then still prevented her from obtaining the abortion care she needed. And Judge Kavanaugh's decision, which would have required the government to continue looking unsuccessfully for a sponsor for an additional 11 days, would have further delayed her care, making it almost 6 weeks from the time she decided to have an abortion until when she could actually receive it.
Thank you. Thank you, Mr. Chairman.
Senator Cruz.
Thank you, Mr. Chairman. Thank you to each of the witnesses who are here. Professor Amar, let's start with you. You are widely acknowledged to be one of the most respected constitutional law professors in the country. In your opinion, is Judge Kavanaugh qualified to serve as a Supreme Court justice?
Unquestionably.
How would you compare his level of qualifications to other Supreme Court nominees without specifically disparaging any other nominee?
I have great respect for all the justices, but if I would actually say, without naming names, that I might rank him. I might predict that at the end of, were he to be confirmed by this body, at the end of his service, he would rank well above the average. I would say in the top tier of modern justices, and the modern justices are quite impressive.
Ms. Sinsdak, you were a student of Judge Kavanaugh's.
That's correct.
What was he like as a professor?
Well, again, he was open-minded, principled. He was very fair. He was also a really nice guy. I take the point of my colleagues that likability isn't necessarily a criteria, so I didn't gear my comments in that direction. But he was wonderfully warm. He took students out to dinner and was very friendly.
So, am I right that you were part of the legal team that brought a challenge to President Trump's so-called travel ban? Is that right?
That's correct.
And in your experience at Harvard with Judge Kavanaugh as a professor, you found him fair, open-minded, willing to listen to views from multiple perspectives.
I did. I like to hope that I used a lot of the things I learned in Judge Kavanaugh's class to bring that challenge against what I still consider an unconstitutional order.
Mm-hmm. Mr. Olson, you served with Judge Kavanaugh in the George W. Bush administration. You were Solicitor General while he was in the White House. What was your experience in terms of any professional interactions you had with him at that time?
We did not have a great deal of professional interactions because his position in the White House did not directly relate to what the Solicitor General was doing. We worked often with the counsel to the President, the White House counsel, but from time to time there were opportunities to see the kind of input that he was providing to the people in the White House, the senior officials in the White House, including the President. He was scrupulous, as far as I could tell, scrupulously balanced in making sure that the President and other senior officials in the department were receiving even-handed presentations, so that he would assure that with one side was being advanced to the President, that the other side was also being demonstrated. His thoughtfulness impressed, I think, everyone around him that was dealing with him, both from the standpoint of the White House and the Justice Department.
Now, you've argued in courts of appeals all over the country. Have you had the opportunity to present oral argument before Judge Kavanaugh in the D.C. Circuit?
I have. I presented the argument in one of the cases involving separation of powers, the constitutionality of the Consumer Finance Protection Board. And we heard that case en banc in the D.C. Circuit. All of the judges were engaged in that case. It was the kind of case that the D.C. Circuit is very good at because it involves separation of powers. It involves the structure of government. All of the judges on that case were engaged. The argument must have gone on for a couple of hours. Judge Kavanaugh was as engaged, if not more so, than the other judges. At the end of the day, he did not agree completely with the arguments that we were making, but he wrote a very thoughtful, reasoned opinion, concurring opinion with respect to concurring dissenting opinion with respect to the constitutionality of the Consumer Finance Protection Board. He very carefully parsed what the Supreme Court had said in the Free Enterprise Fund case and came to a conclusion that was, I thought, very persuasive, although I didn't completely agree with it, very persuasive and reasonable.
But let me thank each of the witnesses for being here on this panel, and I want to echo what Senator Feinstein said in particular. Ms. Weintraub, thank you for your powerful and inspirational testimony. Thank you for being here and being part of this panel.
Thank you.
Senator Klobuchar.
Thank you. Congressman Richmond, thank you so much for being here and for your leadership. I asked some questions yesterday of the judge about voting rights, and I referenced data from the Brennan Center for Justice showing that 23 states, as you know, have now have more restrictive voting laws than they did in 2010. Can you elaborate on the consequences of Shelby County? And as you know, yesterday Judge Kavanaugh noted that Section 2 of the law remains in effect and is, in your view, Section 2 sufficient to protect voting rights?
Thank you for the question. Section 2 is absolutely not sufficient. And for states like the state I come from and some of the other southern states that were Section 5 states which had to pre-clear their actions that affect voting rights, they were not chosen by random. They were chosen because of their past history of affirmatively trying to disenfranchise minority voters. And so because of Shelby, you don't have that anymore. And you saw the race to the legislature as soon as Shelby was decided, where the courts held that the disenfranchisement and the discrimination basically was done with laser-like precision. So
word from the circuit court.
Yes. So you see the voter ID laws. You just saw in Georgia where there was an attempt to close polling locations right before gubernatorial race, with the opportunity to elect the first African-American governor in this country. So it's a big concern for us.
Right, and gerrymandering, as you know, this past term in Abbott v. Perez, 5-4 Supreme Court upheld a number of Texas electoral maps that the dissent said burdened the rights of minority voters. Again, 5-4 decision. Based on Judge Kavanaugh's record, his testimony before the committee, what do you think the future holds there when it comes to gerrymandering with him on the court?
We're very concerned, and if you look at the effect that it has in terms of representation, especially for minorities, and I'm not just saying that, what's important is the ability to elect a minority candidate of your choice. In many instances, minorities choose to elect non-minorities, like Steve Cohen, who represents Memphis, Tennessee, and does an amazing job, but the ability to elect a minority is important. And so if the court shifts towards, makes a drastic shift in terms of gerrymandering, then we face the ability of rolling back the clock in terms of African American and minority representation in this country.
Thank you very much. Ms. Baker, thank you so much. I don't think we focused enough on that case, and you really brought it to light here. Can you tell us quickly why it's important that women are able to access affordable contraception, as well as the impact that you think Judge Kavanaugh's confirmation could have on the laws in this area?
Absolutely. For me, as a Christian, I definitely believe that, one of my favorite Bible verses is John 10:10, in which Jesus says, "I've come that you might have life and have it to the fullest." And I definitely believe that birth control helps us to live our best lives as women. It helps us to go after, education or our careers. Helps us to better plan our families. And when we're ready to have children, and so if and when. And so I really think that is critical to helping empower women and continue the advance forward for women in society.
Thank you very much. And I think the idea here is that you were someone that is pro-life, is that correct?
That's correct.
And you're someone that just simply wanted to be able to afford contraception after you got married.
That's correct.
Right?
Yes.
And so the Affordable Care Act, there you were hoping to use those provisions and to be able to, there's other things in there that's helpful as well, not getting kicked off of insurance with pre-existing conditions, an issue that came up here a number of times in our questions and concerns. But one of them was that you were hopeful about getting contraception that you could afford. Is that right?
That's
when
correct.
You got married.
Yes.
And so then what happened here is you go and you get an IUD, and then you find out that the employer is somehow able to exercise their religious rights. Could you explain that just a little more for people?
Yeah, absolutely. So I had even gone and done my due diligence and checked with my personal insurance company about the benefits and everything, and made sure that it was all clear, not just my knowledge of the ACA, and it said it would be covered. And so when I went to get my IUD, they give a pregnancy test as well, because it was being used as contraception. And so went and got put in, and then a few weeks later we got the EOB for $1,200, and that was about a month before our wedding. And
right.
You can imagine the stress that already comes with planning a wedding, and then putting that on top of it. We're trying to start our new life together, and so it was just a very difficult thing.
Thank you. And Professor Amar, I would ask you questions, but I'm out of time, and also you'd have to recuse yourself since you're my daughter's college advisor. But I would like to note that your comments about the judge having standard, conventional opinions, maybe we can talk about it after, but it just is not my opinion based on looking at his rulings on net neutrality or some of the things he said about Chevron or what he said about the Consumer Financial Protection Bureau. And so I'm looking forward to debating that with you at a break. Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. I would like to thank all of you for coming today. I know a lot of work went into your statements. I find this kind of testimony very helpful. Number two, I want to especially thank my colleague, Congressman Richmond. I've known him a long time before he became a distinguished congressman. He was a distinguished member of the Louisiana House of Representatives. And he is a smart guy and a fine American and a good guy, too. Number three, Ms. Baker, you're a Methodist.
Free Methodist, that's correct.
Right, I'm a Methodist too. When Becky and I got married, I was raised in the Presbyterian Church. My parents founded 2 Presbyterian churches, so I was a Presbyterian, and my wife Becky was a Methodist. So we compromised, and I became a Methodist. Ms. Sinsdak, did I say that right?
Sinsdak.
Sinsdak, I appreciate your testimony too, as I did the testimony of all of you, and I apologize again for hitting you in the head when I was going down to.
That's okay. No harm.
And Mr. McLeod, what year did you clerk for Judge Kavanaugh?
I clerked for him from 2013 to 2014.
Okay. And then you went on to clerk for the Supreme Court after that?
I did, Senator, for Justice Sotomayor.
Okay. And now you're with Williams-Connolly?
Yes, Senator.
You're an associate there?
Yes, Senator.
Have a lot of free time, do you?
Not much, Senator.
I agree with my colleague, Senator Feinstein, that our world is getting better for women. I'm biased, of course, but I think our world is getting better for many Americans. I'm proud of that. In the last 20 months, the United States Congress and President Trump have cut taxes, increased wages, helped create 4 million jobs, delivered 4.1% growth in our domestic product, deregulated the economy, improved health care, I believe, for our veterans, strengthened our military, stood up to China and Iran and North Korea and Russia. And last but not least, we have confirmed some, I think, very accomplished men and women to join the federal judiciary, including but not limited to 1 Supreme Court justice, and I think soon to be a 2nd Supreme Court justice. And I'm proud of that record. And I thank you all again for sharing your thoughts with us today.
Senator Whitehouse.
Thanks very much. Professor Amar, you mentioned recusal, so let me follow up with you a little bit on the recusal question. When you have a judicial nominee whose name has been put forward by the subject of an ongoing criminal investigation and by someone who has been named in open court as directing other criminal activity, in the event that those criminal investigations should ultimately come before the court and the nominee of that subject and that named co-conspirator is then on the court, it is fair to say, is it not, that the question of recusal is a very live and legitimate issue?
Senator, it is, and I think back to the Nixon tapes case where one justice who had been appointed by Richard Nixon and who had worked in the Justice Department and Watergate involved questions about the head of the Justice Department, John Mitchell. One justice, then Justice Rehnquist, did recuse himself from the Nixon tapes case, and 3 did not. My thought is that that has to be decided when the case arises, and there should never be a promise of any sort to any nominator or to this body in the confirmation process about how you'll vote or even how you'll recuse. You decide that when the case comes before you, and Rehnquist decided it one way, and 3 other justices appointed by President Nixon decided it the other way.
Now, since that episode, the Nixon episode, there has been some case law at the Supreme Court developed in the area of judicial recusal, has there not?
There has. One thinks, for example, of Justice Scalia's decision not to recuse himself in a case involving then Vice President Cheney in his official capacity.
I meant actually legal precedent as opposed to behavioral precedent at the court. And I'm specifically referring to the Caperton decision.
Sure.
What is your summary of the Caperton decision?
Thank you, Senator. So one important thing to understand about that case, which arose out of West Virginia, is it involved a state judiciary, a state elected judiciary. And one problem with state elected judiciaries, I know a lot of states have them, I'm not a fan of them, nor is Justice O'Connor, retired Justice O'Connor, who's actually made a crusade of this issue, is you have to raise money to run, and then you don't have life tenure, you have to raise money to run again, and that makes it very different, it seems to me, than a federal judge. One of the great glories of the federal system is once you're confirmed, it's to the Supreme Court, it's a life tenured position, and you shouldn't make any promises of getting it, but even if you did, they're not really, as a practical matter, easily enforceable because you never have to run again. So I see that case as quite distinguishable in important ways. It also involved a financial...
Look at the standard. Look, what was the standard that the court used to apply to the judge in question to determine that he was constitutionally required to recuse himself? Was it not that the funder, by virtue of the amount of funding that he put into the race, had a significant and disproportionate influence on that judge occupying that seat?
That was part of the standard. If memory serves, it's an opinion of Justice Kennedy, for whom Brett Kavanaugh clerked, and there were about 40 different factors, actually, that in the dissent by Chief Justice Roberts were sort of identified as possible limiting considerations in that case. But you're absolutely right, Senator.
The standard was significant and disproportionate influence in putting the judge into that seat, correct?
It did involve a huge financial contribution by a private person in a case that was already pending when the person was running for the state Supreme Court.
Correct.
A pending case, a huge financial contribution by a private individual.
And in this case, you have a pending criminal investigation, and you have somebody who has done a good deal more than put $3 million towards getting that judge in the seat. He has actually 100% put that judge in the seat. Do you not see that there is any potential relevance between the tapering decision and the decision that Judge Kavanaugh would face if confirmed?
May I answer? Thank you, Mr. Chair. So, it's not 100%. That's what this body actually is about. Presidents don't put people on the Supreme Court. And if you had any concern whatsoever that any promise of any sort was made to the president or anyone in the White House about this litigation, I would say you should vote no, because promises are improper. There is another relevant precedent on judicial recusal, and to repeat, when that case comes before the Supreme Court, were Justice Kavanaugh to be on it, he's going to have to make that decision, as is everyone else. I just don't want him to promise anything one way or another as part of the process of becoming Justice Kavanaugh. But I start con law every year teaching Marbury versus Madison, which, as you know, actually has a really interesting recusal question, arguably, in it, because John Adams, at the very end of his administration, is putting his Secretary of State, John Marshall, on the court, and then the case comes before now Chief Justice John Marshall, and there's a real question whether he should have recused himself. I believe he should have, but that's because he had first-hand knowledge of adjudicative fact of the case, but not merely because he happened to have been picked by one president, because all justices are picked by one president or another one and confirmed by a Senate. So it's actually the first question we do in Marbury versus Madison is the judicial ethics recusal question, and I don't think it's sufficient a basis for recusal, just that you happen to have been nominated by a president who happens to be implicated in a litigation. That might not be enough.
Senator Feinstein will be recognized for a correction of the record.
Thank you. I appreciate this, Mr. Chairman, because I apparently misspoke. It is the estimates of the number of illegal abortions in the 50s and 60s that range from 200,000 to 1,200,000 per year. I said deaths. That is not correct.
Senator Hatch.
Well, thank you, Mr. Chairman. Mr. Olson, you've been at the center of the D.C. legal community for decades. What is Judge Kavanaugh's reputation among the lawyers you know, and how is he thought of and regarded?
I do not know of anyone in the judiciary or in the legal profession in Washington, D.C., or anywhere around that who is respected more than Judge Kavanaugh. Now, there are other judges, of course, who have a reputation which is very, very high. The D.C. Circuit, on which Judge Kavanaugh sits, is populated by very, very talented